Po. We work very hard po.
Okay. Ayun, marami pa ako kasing tanong dito sa Twitter. Pasensya na lang po muna yung mga nagtatanong. Kasi meron pang isa for 410. Itong huling nakasala Justice din ng Korte Suprema At saka chairman ko ito Gusto kong maharap May on that note, maraming salamat.
Ay, marami pong salamat at nakakatuwa po itong session natin. Salamat po.
Hindi nakakatawa.
Hindi po.
Nakakatuwa.
Nakakagalak po.
Salamat.
Atin pong natunghayan ang naging public interview ng Judicial and Bar Council kay Justice Maria Lourdes Sereno. At dun sa kanya naging interview ay in-underline niya yung kahalagahan ng konstitusyon at sabi niya itong konstitusyon daw nandito ang mga values na kailangang i-imbibe ng mga miyembro ng hudikatura.
Talagang natanong dito yung age, Sabi nga niya, among the candidates, she's the second youngest, if ever, to be appointed. At lumabas din kung paano rin niya pinag-usapan yung mga desisyon. At isang pertinent na kaso ang nilabas dito, yung issue ng Hacienda Luisita, kung saan sinabi nga niya, hindi daw siya nagbigay ng computation para doon sa compensation na matatanggap nung mga may-ari ng lupa. At in-explain niya ito sa kanilang MR, nung nag-file ulit ng MR ang mga taga-Hacienda. So, ito yung mga issues na binubuhay nga nila. Balikan natin, Gio, itong issue ng edad. Kung sakasakali ay mauupo si Justice Sereno kung siya ay maging Chief Justice ng 18 taon. Attorney Cynthia, does age really matter pagdating sa posisyon ng punong maestrato?
Well, I think it becomes critical because of the experience and exposure, Yung pinag-usapan natin dati ng maturity. But here, I think what's important is, other than that age per se, it's the length of time that they're going to sit as Chief Justice. I think that's the other issue here. Hindi lang yung basta kung matanda ka, kung how old you really are, but more of yung critical issue, how long are you going to stay? Which brings up certain problems. Kung yung sa tagal mo na nandun, ano ba yung maipapasok mo, yung mga ganong issues. But I think, to me, advocate ako ng age because I feel that to some extent, maturity comes with age. But some others can disprove that, di ba? Merong ibang tao na pwedeng i-disprove yun. Marami tayong competent candidates. So maybe perhaps in this particular instance where we choose the next Chief Justice at maging mas bata yung italaga, then perhaps dito na po-prove yan, yung age, whether or not it's really true.
Okay, balikan po natin itong pangyayari sa loob ng Korte Suprema. Nag-uumpisa na po ang pangalawang interview ngayong araw.
And also a pleasant good afternoon. I would just like to briefly cite some highlights in my career as a lawyer and a magistrate. After passing the bar in 1972, I engaged in private practice for 20 years. I became the chapter president of the Cavite IBP, governor and vice president of the IBP for Southern Luzon, and for a short stint, I was selected as national president after the incumbent president entered politics. I was appointed and acted and performed the functions of a commissioner of the Committee on Bar Discipline without any compensation, for the record. And I was selected and appointed as chairman of the National Committee on Legal Aid and also executive director. After that, I was appointed as member of this Honorable Council in 1993. And there I helped in the selection of the best and the brightest for the appointment and promotions in the judiciary. And then in 1995, I was appointed as Undersecretary of the Department of Justice, and I provided support and assistance to then Secretary Chufisto Gengona and later Secretary Silvestre Bello. As Undersecretary of the Department of Justice, I was assigned to supervise the Parole and Probation Administration, the Bureau of Correction, I was designated as chairman of the Board of Pardons and Parole. I supervised the Land Registration Authority. Likewise, I was assigned to supervise the technical staff, the legal staff, the financial and management service. And with that, I developed some experience in management of the different divisions of the Department of Justice. And then I was also designated as Commissioner of the Housing and Land Use Regulatory Board, a member of the Committee on Privatization, and the OIC Commissioner of the Commission on Settlement of Land Problems, or COSLAP. Then I was appointed as Associate Justice of the Court of Appeals in 1998, and later I was appointed on September 11, 2001 as the Court Administrator by the Supreme Court. And at the time that I was appointed as Court Administrator, I was ranked 8 in the disposition of cases in the Court of Appeals. As Court of Administrator, I was in the forefront of the implementation of the action program for judicial reform under then Chief Justice Hilario Davide. In 2002, I entered into a memorandum on policy guidelines with the IBP, and this memorandum was intended to prune case delay and decongest the dockets of the courts with the help of the lawyers. I instituted a total quality management training and workshop of judges, which gave rise to the creation of the judicial service teams in the different courts. I instituted the performance, commitment, and evaluation system of the judges, whereby the judges were evaluated on a regular basis by the executive judges. And in cases where there are single sala court stations, the deputy court administrator is assigned to evaluate the judges. Then I fielded numerous judicial and financial audit teams, and we were able to discover numerous malversations of filing fees and fiduciary funds. In 2004, I recommended the guidelines on pretrial and modes of discovery and deposition. On March 18, 2006, I was appointed Associate Justice of the Supreme Court. Then I was later designated as Chairman of the Third Division upon the retirement of some of the more senior members of the Court. I'm also at present the Chairperson of the House of Representatives Electoral Tribunal. At present, I have 181 judicial cases pending and 87 administrative cases, or a total of 268. With respect to the number of cases pending in the docket, I rank second behind the Senior Associate Justice Antonio Carpio. Thank you, Your Honors, for giving me the opportunity to make an opening statement.
Attorney Cayusa, please.
Thank you, Justice Peralta. Good afternoon, Justice Velasco. Well, we are together again. If you recall, I used to sit as court attorney for then Representative of Congress, Senator Marcelo Fernan, in the prelims. And that was, I think, my internship. And it never crossed my mind that one day I would be here as a regular member. Anyway, as you mentioned, you served as National President of the IBP in 1987. And in that brief stint, I believe your biggest accomplishment was the financial stability of the IBP by wiping out the indebtedness of IBP with the GSIS by the reduction of its penalties and interest as a result of its loan to build the IBP building. And because of that, IBP is benefiting and we are financially sound. That being the case, and knowing the inadequate budget of the Supreme Court, if nominated and appointed Chief Justice, what would be the priorities in your budget for the Supreme Court?
Well, we really have a big problem with the budget for the Supreme Court. For the past several years, up to 2010, I believe our budget hovered only at the range of 0.8% of the national budget. And in 2011, I was informed that our budget was substantially increased to 1.21% of the national budget. And this is really a dramatic increase. And likewise in 2012, for this year, I believe we were given a budget of around 1.07% of the national budget. And we are grateful for this substantial increase in our budget because, as I stated a while ago, before, we used to get only 0.8%. And even, I think it even went lower than 0.8. It became 0.79 in 1 year. So I have to express our gratitude to Congress and, of course, President Benigno Aquino III for this substantial increase in our budget. But still, later on, I hope I will be given the opportunity to discuss the problems that confront the judiciary at present. And I will discuss, if you will allow me, the need really to provide a big amount of money for the construction of courtrooms and the purchase of the needed equipment. And when I say equipment, it covers not only the furnitures and tables and the supplies, but we want to really acquire already the equipment pertaining to our ICT programs. So there is some amount given as capital outlay in our budget, but then that will not suffice for the construction of the courtrooms needed nationwide. If I have gone around in my stint as court administrator for 6 years, I visited the different court stations, and I'm shocked to see courtrooms which are in a very state of repair. It's so dilapidated, and it's a shame for us to show to foreigners, and more so people from the judicial branch in other countries, that we will find a courtroom like this in our country. And so we must get full support of Congress and the President to provide the judiciary with the adequate funds to come up with the well-equipped and well-constructed courtrooms that can withstand the elements. And as you know, we have had several courthouses seriously damaged by the typhoons and even by the floodings. And so we really need a big budget. But we know that this cannot be done in one sitting. It has to be done on a staggered basis. And then, of course, later on, I will discuss the need to create more courts. And so, aside from the fact that right now we have to repair and refurbish the existing courtrooms, we may really have the need to construct more courts for these new court stations that must be created by law to solve the high caseloads in the dockets of some of our court stations. And I will discuss that later. So the support of the two other branches of government is quite important in our task of delivering swift but genuine justice. we cannot do it by ourselves. Probably the 20% that is earmarked from the JDF should be studied carefully, because it creates the wrong impression that the 20% may be sufficient already to finance the construction of the courts that have to be repaired and the construction of new court rooms. But it's not. It's not sufficient. It's not ample. So probably we may have to seriously consider that the 20% should already go back to the National Treasury to avoid the wrong perception that it is sufficient to finance or the repair of the existing courtrooms, so that we can present clearly to the Department of Budget and Management the actual financial requirements for the infrastructure and the courtrooms needed in our judicial system at present. And the ICT has to be used already by the courts if we are to deliver swift but inexpensive justice. We have developed the enterprise information system plan, and there is a need to come up with around $15 million to set up the equipment so that all the courts nationwide will be linked to our main data center here in the Supreme Court. And that's a huge amount of money. And even the Hall of Justice of Manila was delayed for some time because we were relying on a loan to be given by the World Bank. And finally, we were able to locate some funds, and that will provide the initial funding for the Hall of Justice. But then there are other courtrooms that have to be repaired, and there is really a need to construct more courtrooms, Madam.
Thank you, Justice. On another vein regarding finances, in some LGUs, they provide judges with an allowance. What to you would be a way to modify or to improve the policy on the acceptance of this allowance in order to ensure that the judges remain independent?
Well, I encountered that problem, Madam, in my stint as a court administrator, and it's true that the independence of our judges who receive these allowances and perks from the local government may be somewhat already compromised. I know of a situation where a judge who issued a decision adverse to a mayor or the head of an LGU, and the result of that is that well, I think the allowance was withheld, or sometimes they deprived them of some privileges. And I heard of a judge who's supposed to get the allowance directly from the head of the LGU. And the head of the LGU even asked the judge to receive it after 12 o'clock. So it really adversely affects the independence of the judges. And what I propose, and I think this has been proposed, and this has been done in Makati and in Cebu under then Mayor Tommy Guzmania, is that all this financial support should be placed in a judicial trust fund to be managed by the Supreme Court, so that there can be no issues as to the independence of our judges. So probably this is the opportune time also to state here, Madam, if you will allow, that in the construction of the courts, I believe that the LGUs who are financially capable should be the one obliged to spend for the construction of the courtrooms. They have done that in Parañaque, in Marikina, and in Makati. And I don't see any reason why the other LGUs who are equally financially able to provide the funds should not do it. Because anyway, their constituents are the ones being serviced by our judges. And I believe that even the utilities should all be paid by the LGUs. And if I'm lucky enough to be first nominated by you, hopefully, and then appointed, I will work towards this trust of talking with the heads of the LGUs for them to take care of the construction of the courtrooms, to provide the equipment, and also to shoulder the utilities. And probably that is the way that the LGU can amply support the courts in their respective jurisdictions. It should be done that way rather than by giving allowances and perks to the individual judges. Actually, the giving of the allowances and perks should be the concern of the Supreme Court. And so I believe these should all be put in a judicial trust fund, and then probably the judicial trust fund should be the one that will be utilized for the construction of the courtrooms and the purchase of the equipment and the payment of the utilities, Madam.
Thank you, Justice. Something that you are familiar with respect to the IBP again. Well, 3 years ago, we belatedly assumed office as members of the Board of Governors. And in fact, you attended our oath-taking. And instead of having the full complement of 9, there were only 6 of us because there was a controversy. Now, there was a controversy with respect to the election of governor in 3 areas. Would you suggest any amendments to the rules of the IBP, particularly on the election of governors or even the representation, and including that of the executive vice president who will ultimately become president, to ensure that first, people of integrity and competence are actually elected, and second, that it is devoid of any controversy similar to what we experienced in 2009?
Putting people there of competence and integrity may be up to the members of the chapter first, who elect the chapter president and the other officials, and then if the members will select chapter presidents of integrity and competence, then definitely these people, these chapter presidents, will elect a governor also of the same qualities, having those qualities of integrity and competence. The rules of the IBP are to me clear. However, there is a rotation in the selection of the governors. Sometimes that is not strictly followed, and for one reason or another, the particular chapter does not opt to field lawyer who will be selected as the governor for that region, and that's a big problem because it really disrupts the rotation. But we cannot do anything about that because it's possible that the person who's supposed to be the governor for that region may not be, as I was told, possibly not financially capable also of being or performing the job of the governor or governor in the meantime, because he has to travel from his place to Manila every now and then. So that will entail some expenses. Well, there may be some rules in the bylaws that have to be clarified, I guess, and that was the issue in that case where we have to determine who really should be considered as delegates. And I guess that is one area where the bylaws should be amended, and that should be clarified. It should be clarified. It's just like deciding a case where legal provision is susceptible of two interpretations, and the magistrate who's supposed to decide the case will have to resolve which, to him, is the correct interpretation. And then you have to go to aids of construction, aids of in statutory construction, or aids for constitutional construction. So there may be some gray areas there, and I think it's about time that the bylaws of the IBP should already be reviewed, because it's not only that particular provision that may have to be clarified or enhanced. Probably it's about time that the Board of Governors consider the review and possible amendment of the bylaws, Madam. I hope I satisfied your question.
Thank you, Justice. You were also a commissioner on the Committee on Bar Discipline. Just one short question with respect to bar discipline. Considering that the Board of Governors actually acts on the bar discipline cases, and they recommend to the Supreme Court the action to be taken in a disbarment case, do you believe that you should include as part of the disqualification to be elected governor that they should not have had any case wherein they were sanctioned, particularly suspended, similar to the rules in the JBC for judicial positions? If they have had any administrative case where they are actually suspended, that would render them disqualified for the position of governor. Do you agree with that?
Well, I agree with that, because right away he will not have the respect of the lawyers in that region. And I agree that the bylaws of the IBP should be amended to put that as a qualification, as a ground for disqualification even, so that lawyers with pending administrative cases, or those which who have been sanctioned already, should already be disqualified from occupying positions in the IBP. I agree with that, Madam.
Thank you, Justice. And my last question.
Okay.
What made you accept your recommendation to be nominated for the position of Chief Justice? In other words, why do you want to be the next Chief Justice?
Well, to be frank with you, Madam, I had a difficult time deciding whether I will accept or not. For one, I believe that Senior Associate Justice Antonio Carpio should be appointed to the position, because I strictly follow the seniority in our court. Remember when Chief Justice Puno retired and the position became vacant, I withdrew. I did not accept my being considered for that position, because I believe that the two senior justices should be the ones to be seriously considered for the position. So I had the change of mind, because I said I may just be considered as a selfish person if I will not allow myself to be considered for nomination, because I realized that I have a wealth of experience behind me, not only as court administrator, but by being in the Court of Appeals, and I know the operations and the problems that confront the Court of Appeals and even the appellate courts, the other appellate courts like the CTA and Sandigan Bayan. And then I was the Undersecretary of the Department of Justice, and I came to realize also that the two pillars in the criminal justice system were under me before, the Public Attorney's Office and the Bureau of Corrections, the BUCOR, plus the fact that at one time I also supervised the National Bureau of Investigation. Then, when I was court administrator, actually I initiated the organization of what we call the National Council on Administration of Justice, and it was during the time of Chief Justice Hilario Davide, and the composition of that council is that we have the Secretary of Justice as a member. Actually, we designated him as the chairman, and I represented the judiciary as court administrator. And then we involved the DILG secretary. I think at that time, if my memory serves me right, I think Secretary Datomano or somebody else, I'm not sure. But so we had several meetings of the National Council, and the objective there is really how to reduce case delay and decongest the dockets of the courts, no? And it is it's a good forum where the different pillars or the agencies that supervise the pillars in the criminal justice system are present, and all the problems that we encounter in the prosecution of criminal cases were brought up, and right away we were able to arrive at concrete solutions, because the DILG has the control of the law enforcement agencies, and we have a problem with the policemen, and sometimes they don't arrive for the hearing as witnesses. Sometimes they have a problem with the service of the subpoenas, to whom, the courts entrust to them the service of some subpoenas and court processes. And then, of course, the Secretary of Justice has the control over the prosecutors, and we have a problem with the prosecutors. And I know for a fact that we need more prosecutors if we really have to speed up the delivery of justice concerning criminal cases. And then we have the PAO. The PAO is under the DOJ, and the public attorneys have a big role to play in the expeditious termination of cases. So all these things were brought up. And so I also had exposure to the problems of the practitioners when I was in practice, and in the selection of nominees for the judge positions when I was JBC member. So I said, probably I'm being too selfish if I will not throw my hat into the ring. And so that's why I'm here. Although I was thinking I may not even have a ghost of a chance of being appointed, but probably I can make use of this interview to probably shed light on the problems that confront the